Sorry about laughing because this is not a funny topic. This is not comedic or satire. This is true.
Welcome to Order in the Court. I'm Brian Blakely.
And I'm Chief Legal Analyst Khalif Rhodes.
Khalif, good to see you as always, man.
As always, it's good to see you. Good stories, right?
Yeah, we got three great stories, as we always do here on Order in the Court. And the first one we're going to be talking about is this case of teachers in Oklahoma City and students. It looks like they're not going to be the only ones that are heading back to class right now. They're now required to take tests to determine how conservative they are. Oklahoma leaders, they call it the American Teacher First or First Teacher Certification Test. The Education Department is about the difference between men and women. And if the 2020 election was stolen, what say you, Counselor?
Sorry about laughing because this is not a funny topic. This is not comedic or satire. This is true. So this is the American First Teacher Test that we're talking about, where these states I should say, individuals that are leaving New York, California, and there's a couple others that they have on the list. If they come from those locations, the state will want to attempt to try to find a way to have them take this test at Oklahoma. So I have a couple concerns. I mean, you got something called the Constitution. I think if we're talking about educators, we want to make sure that we understand what the Constitution says. First of all, we got the 14th Amendment that talks about equal protection. You can't have rules against one member from a state and then different rules from a different member of a state. I think that's pretty clear. So if I'm an applicant from North Carolina, I'm an applicant from Pennsylvania, our applications have to be the same. If they're not the same, that's a cookie cutter violation of the 14th Amendment. First Amendment violations. Speech is protected. It can't be chilled. You can try to chill it all you want, but it can't be chilled unless you can jump over a couple hurdles. First hurdle is that it needs to be compelling public interest. This is that strict scrutiny test that I'm talking about, or it needs to be it needs to be narrowly tailored. Now, there could be a couple other ones. There's a lower standard that can be done as well, but in this situation where you're talking about speech, it's going to be that strict scrutiny, and it would be hard for the government to point to a way you can violate someone's political ideology. That's a constitutional protected, or I should say at least protected case law. And so because it's protected, it would be hard fast for me to see that this wouldn't be a First Amendment violation. Then the other part is you're conditioning your public employment, right, on your allegiance to this political ideology. So if you don't believe the way that I do, now this job that's paid by taxpayers that have views on both sides of the aisle, if you don't fall into this specific side of the aisle, now you can be denied employment. I think those two on the arguments for the First Amendment alone shut this down, First Amendment, 14th Amendment. But then you got due process, you got interstate commerce clause. There's so many other ways that you could shut this down if you've been violated, or I should say been subjected to this test.
Well, then why even do the test in the first place if it will not stand up to a court of law because of the things you just listed in what you're talking about as far as it not being, not passing the test?
Not being constitutional? Well,
Yeah.
a couple things. You got aspirations, your dreams to go from the seat you're sitting into another seat oftentimes propel you to do things that you shouldn't do. And so this individual right here is no stranger to his 15 seconds of fame. And this is just another attempt of him to do that. We're talking about the chief superintendent of the state of Oklahoma. He's now attempting to be, as he says a couple of times, I want to be the commander in chief. I want to be, the most MAGA individual in the country. And so if he's auditioning for that role, if he's putting himself in that position to be the most MAGA of the MAGA party, then these are the types of things that you would do that tap into your base, because you're saying catchphrases and buzzy words like, America first and Christianity and religion. And but when you look at what our Constitution says, it talks about religious freedom. It talks about separation of church and state. It talks about First Amendment being able to have the ability to still provide that pursuit of happiness, but also providing for your family while not having to fear the things that you say, if they're not hate speech or inciting a riot. And so these types of things will play into the base. So here's the question of why you do it, because it grabs attention. If he was saying, we're doing everything in our power to keep it as conservative as possible, that wouldn't have the same ring to it as we're going to make you take an America First test. Hey, all the lights and bells go up at that moment.
Yeah, and also the one thing that raised our eyebrows here too is one of the questions that they asked is if the 2020 election was stolen. Well, that is certainly meat for the red the base. But the election was not stolen. It's been litigated over and over as far as that goes. So it's almost like you're trying to rewrite history here.
It is, and then while at the same time saying they don't want people coming there teaching ideology to students, to continue the narrative, the idea, the thought process that somehow there was a stealing of the election and that Joe Biden didn't actually win. While you're saying that these teachers can't teach their ideology, their thoughts. This seems to be something that's not based on facts, not based on reality. That's a far stretch, a grasp at straws in terms of the information that we've seen from every legitimate investigatory agency. No one has said that anything like that occurred, but yet these are the things that are repeated on that side of the house. So then what you have happen is you'll now have folks not wanting to attempt to go here. Now, the other
And that's the other thing, too. It discourages teachers from applying in the first place there.
It could with ish, right? Not 100%. Why Oklahoma is even in the news now, there was a decrease in teacher applications across the country. What does Oklahoma do in response? Offer $50,000 sign-on bonus. So some teachers are making $50,000 for their year,
Wow.
and you're offering a $50,000 sign-on bonus. And so what do they see? An increase in applications. Applications are, running through the roof because everyone's trying to figure out how they can get that $50,000.
And they're getting them from blue states like in New York and New Jersey.
They are, but I'd equate this to the same thing that we talked about with the redistricting in Texas. You got that redistricting happening in Texas, and so while President Obama during his DNC speech talked about how we are these United States, right? There's not red states and blue states, but we're getting further away from that theory and closer to this extremely red and extremely blue, no purple type of states, where either you are for us or you're against us. And so what will happen is you'll have places like California that will have all liberal thinking teachings, and then you'll have places like Texas or Oklahoma that will have all only conservative teachings, and the students that come out of those places where there's not that diversity of thought, we are learning only from people that agree and think just like you, will have a detrimental effect on us as a community, because when those kids go to college, ultimately the statistics won't be that everyone will stay in state. So when you leave and go to a place that doesn't look like the state you were just in, then it'll be a rude awakening. It'll be a wake-up call to learn and to hear and to have discussions with people that have thoughts that are different than what you've heard for the last 18 years. And so that the secondary effects of these types of things will have generational lasting impacts on the kids to come.
Yeah. All right. We're going to leave that one there right now, and we're going to move on to our second subject coming up here after the break. And we're going to be talking about the FTC versus Media Matters and good old Elon Musk and Twitter, now X. In that case, when we return here, you're watching Order in the Court here on Queen City News Plus. We'll be right back. All right, welcome back to Order in the Court here. As you got Khalif and Brian here, we're talking about our second subject here today. It's the FTC versus the Media Matters federal court case. FTC launched an investigation into Media Matters, a progressive watchdog group, after it published reports on ads on Twitter that appeared alongside anti-Semitic posts following Elon Musk's acquisition of the platform. The federal judge there in D.C. granted a preliminary injunction blocking the FTC from continuing its probe.
Yeah, well, the judge said, and I quote, that this case presents a straightforward, not a crooked, not an uphill, not some downhill, but a straightforward First Amendment violation. And so that's why this case is able to go forward. When issuing a preliminary injunction, folks have to remember that this is an extraordinary relief. The courts are reluctant to issue an injunction, being a preliminary, temporary, or permanent injunction. And why? Because they typically, if you file a claim, what they want you to do is go to court. They want the case to be resolved through the typical process without having any type of hearings or anything in the middle before you get a final resolution. Well, an injunction throws all that on its head. And it says, Your Honor, before you can hear this case on the marriage, because I don't want to be harmed in a way that money can't fix it, I need you to pause what they're doing and stop it right now. So irreparable harm, likelihood of success on the marriage, this balancing of the equities and the public policy, public interest. That's what the court will go through when they make that assessment of should I grant an injunction, should I not grant an injunction? And that's what happened here. Media Matters is saying that this is retaliatory, that the only reason that this is occurring is because we spoke out against you. And when we spoke out against you, big brother, you government now has made an opportunity to try to make an example out of us. And you're going to now, create this investigation into us for doing nothing but what we do. We're a watchdog group. We look for folks that are doing things that are inappropriate on the internet.
One of the hallmarks of democracy, holding those powerful accountable.
Holding people in power's feet to the coals.
Mm-hmm.
If you turn up the heat, they should be able to withstand it if there's nothing that's happening that's irregular. And in this situation, this group right here, Media Matters, is saying this is what we do, Your Honor, on a regular basis, routine. We're asking for a common sense approach to what you do in media spaces, specifically social media, with the information that you're providing. And if we see an uptick in anti-Semitic information since you've taken over, it's our job to report on it. I mean, that is what they do. And so it's like you're going to the mechanic and you ask them to change your oil, and then you're frustrated that they're changing the oil. Well, this is what these guys do. They're not a government agency. They're a watchdog group. But for you to now...
weaponization of the government, though.
But for you to now create this investigation into them, they're asking that to stop, and the court has now allowed that portion to stop as their case moves forward.
And we've seen this a lot, though, the attack on the free press, the attack on this type of thing, trying to squelch any type of the investigative type of pieces of journalism that are coming out, bully the journalists. And, that's the hallmark of one of this administration right now, because, they don't want people telling exposing a lot of the truth about what's going on.
I wholeheartedly echo those same sentiments. The president and chair of Media Matters said the same thing. It's a critical test for whether the court to allow any administration from any political party, here's your words, to bully media and nonprofit organizations through illegal abuses of power. And so we'll continue to stand up and fight for the First Amendment rights that protect every citizen. That First Amendment's important. I mean, we have so many cases that talk about like what you can do, what you can't do. It talks about speech, and that's your words, but it's also your actions. If I wear a shirt that's pink, and I want to wear it today, and you now are trying to stop me in a public place from wearing it, that's my speech. The courts have held that my access to speech also is protected. So if you're a website and you're limiting my access to opportunities to get on there, if it's a public type of forum, and the courts are now viewing these websites, these social media places as public discourse forums, which now have afforded these First Amendment rights there. If you're now attempting to quell, to chill, to stop, to limit, to prevent, to discourage my speech by ways like this, why you're now will bring the whole weight of the federal government in attempt to stop you from doing what you do. And then now you have to have the resources. You got to ensure that you have people supporting you that will allow you to go the distance to go to court. Because if they were a non properly funded organization, one hint of the FTC coming, that most people would have folded up and said, all right, well, you win, I lose, I'll let you guys do it. But because who they are at their very nature was a watchdog group, they were ready for the fight, and now you had the financial support to take this the distance to go to court. Most people aren't doing that. They will feel wronged, and they'll just be upset about it.
Or do they have the money?
You got or don't have the money. And in this situation, I think it was the perfect storm. You have an administration that has zero concern for ruffling feathers with folks. And then you have this Media Matters that's like, hey, I want to be able to do my job without being fear of repercussion, any type of reprisal, retaliatory, anything like that. Because now I have to think about, well, if I type this, if I say this, if I put this up, what happens to me? What happens to my family? What happens to the people that are connected to us? And so those are the types of things when you talk about the public policy, that balancing of the equities, that's why the courts would want something like this to be stopped, because you don't want to show that precedent going forward of this type of behavior is okay.
Yeah, you're interesting anecdotal information right here as far as Twitter. We've seen like even our Queen City News information that goes out has been throttled back quite a bit, extensively, as our digital team will talk about, of any stuff that we put out on Twitter, X. It's just the new algorithms or whatever they are. You don't get any engagement anymore through the normal free press.
It is definitely significantly limited since Elon Musk has taken over, where you can look at the numbers from the day and look at them now, and you can see a steady decline in terms of engagement.
In types of engagement.
What we were talking about before Elon took over there at X and then just in social media in general was this increase in misinformation. And that's what Media Matters was doing. They're not just watching. They're looking for misinformation and trying to figure out ways to stop that misinformation from being out there. And so bringing awareness to it and letting folks know that it's there can stop the misinformation from spreading. That's the goal, right? But what they're saying is, that, as you mentioned, it's been significantly limited in terms of the true, natural, organic way of folks would see it on their threads and on their feeds. But then you see this in this anti-Semitic information that's being placed out there. So those are the types of things that groups like Media Matters, and there's a whole slew of other folks that do this type of work that are trying to figure out, hey, will I be protected after this case? Well, for right now, we know that you'll be protected because there's First Amendment laws in there to protect you. But do you have the resources, as we mentioned before, to go to court and be made whole because they're trying to deny you that opportunity?
All right. It's Chief Legal Analyst Kali Froese. We're in order in the court right now. That is our second topic of the day, and we're going to take a short break. We'll be right back. When we do, we're going to be talking about the comedian Eric Andre, who was stopped at Atlanta's airport, and he says it was racial profiling. We'll have much more on that one coming up, where you're watching an Order in the Court. We'll be right back. Welcome back to Order in the Court here on Queen City News Plus. We got Chief Legal Analyst Kali Froese and myself, and we're talking about our third subject today. Eric Andre, comedian. You guys may know who he is. Well, he was stopped at Atlanta Hartsfield-Jackson International Airport. He says he was racially profiled.
Listen, there's nothing funny about this. This is not comedic. He wasn't trying to do a joke. At first, when I saw it, I was like, oh, man, maybe this is some bit, some stand-up skit to try to connect to some, movie or whatever he's running. Happened in 2021 at the airport in Jackson, Hartsfield-Jackson, I should say. Parts of that airport is Atlanta, but parts of it is Cobb County. And so when he made the report originally saying Atlanta police, it was actually Cobb County. I mean, he later found out through the discovery process, but he's saying he's walking to the plane on a private plane. He sees a row full of white
private plane, no less.
Right.
Yeah.
Sees a row full of white passengers, and folks don't say anything to them. He said when it gets up to him, two plainclothes officers walk up to him, and it's like, hey, man, and this is the language they use. Do you mind if we search you? Do you mind if we look and check you out for a second? And then he said the guy starts to say, you're on drugs. You smell like drugs. You look like you've been using drugs. And then he goes, I don't feel comfortable with this situation. And he kind of looked at the older officers, how he described it. And he says, well, do I really have to allow you guys to do this? And the guy says, the older officer had that face like, well, you kind of don't have to. And he was like, well, I don't want to do it, and walked away. So then the question is, well, A, was that time frame enough to say that I was detained? And then was it enough to be able to show that I was profiled based on race? Have you violated my constitutional rights, my due process rights for equal protection for the 14th?
Jim Crow racism was what he says here from Clayton County PD.
And it was definitely something that had him extremely frustrated outside the normal scope that we have seen him in, which is more from a comedic time frame. I watched one interview with him. It was probably about 5 minutes. He says, this is the longest I've ever been on camera without trying to make you laugh, right? So I get it. But to the first question, I say this a lot of times when I talk about our Constitution. It's easy to forget why we have these rules in our Constitution and why we have these amendments.
Democratic society, that's why we do it.
Right. But also because we were fleeing persecution. So we have these drafters and these writers. They're all in these rooms, and they're writing these things in Philadelphia and in Boston and trying to find a way to make it not like the king monarch system that we were coming from. And what was fundamental, what was extremely important was our obviously First Amendment, that right, the free speech. But then tucked down in there under the Fourth, it was this constitutional right against illegal search and seizure, to be able to not be detained, to be stopped, to be harassed, to be locked up without having some type of warrant, without some authority to do that. And so in this situation, you asked the question, even if it's brief, have you detained this individual? The courts have said he was detained. And so the court allowed part of his claim to go forward and part of it not. So the based on race claim, the court didn't see that there was enough information submitted and couldn't find a factual basis to support allowing his claim to go forward based on race. But they did say that based on the 14th Amendment, there were some constitutional issues with what transpired. I mean, in Fourth Amendment issues, I should say, which transpired. And because of that, his case will go forward on those Fourth Amendment issues. That was he detained will be the question. And how long can you detain a person That's the question that you
Was
have
there
to
body
answer.
cam footage of this that could detail a little bit more about what happened here?
Not that I've seen so far, and I think it would give insight, but it also you want to see the body cam footage. You want to look at the clock. There's a lot of things like when did the investigation start? At what point did you start talking to this individual, and at what time did he leave your presence? That's helpful. A lot of cases I looked at when I was in law school talked about the detention and how long the detention lasted to see if you had violated a person's right without having that warrant. The other thing is that having a voluntary stop, and that's how Clayton County in the in the airport talked about these type of engagements and encounters, right? And there's a ton of case law supporting this, where you have an interaction with law enforcement and they ask you the question, well, would you mind? Do you think you'd mind if you don't mind, I'd like to have you do this. Those types of statements are voluntary. However, you would think if you're engaging an officer and they're asking you for anything, that I have to do it, right?
Correct.
And that's what people have sued. And I will tell you this, the courts have not bought that argument. The courts have historically held at the Supreme Court level that a voluntary stop where they ask you, will you participate? Do you mind if you participate? They say that a reasonable person would believe that they're free to go in those situations. Even though you and I, believing if we're stopped right now walking down the street and an officer, John Doe stops me and says, hey, do you mind if I search you? I'm not believing I'm free to go. I would ask him, am I free to go? Are you detaining me or am I free to go?
If you say no.
Right. But those are the types of things that where there's a disconnect between like what happens in these stops and the people that are getting stopped. Because if you've ever had any interaction with law enforcement, when they start talking, I'm just trying to make sure that I get out of this interaction without going to jail.
Yeah. So what happens in this case? Where does it go?
I think this case goes to court. It continues to go like the process that it's been doing. That his claim for
Do you want a settlement here?
Well, sometimes you want training. Sometimes you
Pound of
want
flesh.
money. Whatever.
Make a statement.
Right. Whatever your request is, that it really just comes down to the client. I think part of what he's asking for is them to recognize what they did was wrong. So that accountability is the first part. A lot of times this is embarrassing. If you've never been pulled over by the police, never been detained by law enforcement, it is probably one of the most embarrassing things ever, especially if you've not done anything. If they're having a conversation with you and you are 100% within your rights, it is
even for a traffic stop. And they were asking him if he had drugs on him
at the airport.
Yeah.
And so those are the types of things where he's confused, concerned, and now you ask what happens next. He can appeal the court's decision to dismiss his race-based claim. He obviously can go forward with his original claim based on the Fourth Amendment violations. And I think ultimately, once this is over, it will lead to some type of settlement. Clayton County Police Department will have to validate their process. His attorney talked about a number of things. They looked at the numbers. When you do discovery, you get the data. So he said they were over 200 plus stops over the time frame they looked, and over 50% of those were for African Americans. 56%, I believe, is what he said. And so he's saying that the population of Atlanta, the population of people that come through the airport, isn't at 50+%. But yet you're saying that on a 50+% basis, where you're attempting to say this is random, that more than half of the people that are stopped are African American. Their argument is that there's nothing random about the test, that this stop was more race-based than anything.
Yeah. All right. We're going to certainly keep following that one. And also I'll try to follow comedian André a little bit more after he learned a little bit more about him and get a few laughs instead of talking about all the bad things that have happened over because when you drag out a court situation like that takes a long time.
It does.
And it wears on you. All right. Chief Legal Analyst Collie Rhodes, you've been watching Order in the Court today. It's Queen City News Plus.
Queen City News Plus. Just search Queen City News on your smart TV's app store.